Okay, may all be seated. We are hearing for this case, State Andreas versus Boogie Scott, 21-16279. Judge Mann presiding with the Honorable Judge Peterson. Is the prosecution ready to move forward?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
Okay. The court will acknowledge that Mr. Boogie Scott is not present at this moment. And at the end, a failure to appear will be applied at the end of the trial for Mr. Boogie Scott. We're going to continue on with trial.
All right.
Unless the other side has any objections.
Thank you for the follow, youngin.
With that being said, Mr. Hall, you have the floor.
Thank you, Your Honor. Oh, ladies and gentlemen of the court, today we're going to have a pretty simple case before us. Now, it's going to be shown beyond a reasonable doubt that on the night of... Just one moment here. Apologies. On August 24th, in the year 2021, Trooper Ward and other officers with him responded to multiple calls of shots fired in the Paleto Bay area. More specifically, in the Paleto Bay area surrounding the motel and bank in Paleto Bay.
What's the FW mean?
Officers, they responded in heavy force. And when they arrived in that area, they looked for anyone that they could find. And when they looked, ended up finding the defendant, Mr. Scott, hiding behind some trees in a public area that was meant to be constructed. Now, of course, in that area, Trooper Ward encountered the defendant. Of course, he saw that the defendant was in the area, the immediate area, rather, of where shots were being fired. He noticed that the defendant was bleeding from what appeared, from his point of view, to be a gunshot or some major sort of wound that would indicate a fight or struggle of some sort. So, Officer Ward, he approached the defendant. He detained him, of course, to initially question and ensure that the scene was going to be safe with him speaking to the defendant. He ended up frisking the defendant because that defendant was specifically an area where shots had been fired. And via frisking the defendant, he immediately felt a large firearm, leading, of course, for Trooper Ward to search the defendant and then finding the rest of the weapons that have been submitted into evidence. Now, overall, of course, it is going to be shown beyond a reasonable doubt that Mr. Scott has no defense in terms of him being in possession of a Class 2, Class 1 firearm, refusing to answer whether or not he actually had weapons on him, whether he had drugs on his person. Overall, today, it's going to be made pretty clear that all such frisks, searches, detainments that were involved in this case were lawful. So, Your Honor.
Thank you, Mr. Hall. Mr. Vandeburg, you have the floor.
Yes, Your Honor. Your Honor and co-presiding Honor, people of the court, on the date in question on August 24th, 2021, from what was noted on the docket around 4:30 a.m. Eastern Standard Time, defense is going to try to counter what prosecution's trying to prove today, their reasons, and going forward on pressing charges against my client. From how they obtained my client to going forward after reasons were not necessary. And we will be arguing the evidence. That is all, Your Honor.
Okay. Does the state have any witnesses they wish to bring?
Yes, Your Honor. The state would call Trooper Ward to the stand.
Mr. Ward, if you could please approach.
Trooper Ward, if you would, please go ahead and raise both hands for me. Face me. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Hey there, how's it going today, Trooper Ward?
I'm doing well, sir.
Oh, very good to hear. You go ahead and state your full name for me.
Trooper Nicholas Ward with the San Andreas State Police.
Let's see now. Sir, with the San Andreas State Police, do you mind if I ask first what your position within the state police is and how long you've been there?
I've been a trooper.
Oh,
within the
objection,
state-
Your Honor. That's a compound question.
I can rephrase, Your Honor.
Can you
Trooper
rephrase it?
Ward, what's your position with the San Andreas State Police?
I am a patrol trooper within the state police.
How long have you worked for the state police?
We're going on 3 months now in total.
Do you have extensive training in matters of searches, seizures, and overall determining probable cause and reasonable suspicion?
I do.
So overall, you have extensive training in the law as a law enforcement officer.
I'd like to think so.
That's very good to hear. Now, can you describe as to what call you're responding to around 4:30 in the morning, on August 24th?
I can. I responded to reports of shots being fired near Polito Bay, accurately on Procopio Promenade near the Polito Bank.
Okay. Now, again, can you recall specifically where those calls were coming from? Now, was it spread out throughout Polito Bay, or was it condensed within specific areas within Polito?
From the reports that we were being received as we were en route to the location, it was in a confined area.
Now, was it only yourself that responded to these calls, or were there other officers who responded as well?
There were other officers responding.
Okay. Now, around. Let me rephrase that. What did you see when you first arrived in Polito Bay?
I saw multiple blacked out sports cars on the streets of Polito Boulevard. As I canvassed the area further, that's when I found the defendant moving towards Procopio Promenade from the north.
Okay. Can you describe exactly where on scene he was? Or what type of area it was?
Yes, he was emerging from the north cliffside of Polito Bay towards Procopio Promenade from behind a orange in color house.
Okay. Was he on private property or public property, to your knowledge?
I cannot say at this time. I do not know if the property he was on was his or was not.
Okay. Did you notice anything with the defendant immediately in terms of where he was positioned or anything close by him?
I don't know if I should
From
post
the
this.
area he emerged from behind the orange house, I noticed that he was in the area of the shots fired that was reported. And also he was coming from behind a house which, in many shots fired calls I've been to, can be used as cover in a shootout.
Okay. Now, you were on the radio at this time, correct?
Yes, I was.
Okay. Now, did any other officers over the radio state that they
Fuck it, don't care.
saw other individuals in the area?
Not at the time, but we were still canvassing the area. The defendant was one among the first to be spotted.
No, that side doesn't have a microphone right now, which is unfortunate.
Trooper, could you please walk over towards my my chair and stand over here where there's a little microphone? If you would just move it, that way the whole court can hear you.
Apologies.
Right. So,
Okay.
just to clarify, you arrived on scene, right? You immediately saw the defendant creeping behind a house, right? There was no one else on scene that yourself or other officers saw.
Initially, that was the case, yes.
And he was on the scene of where these calls of shots fired were, correct?
Yes.
Now, what did you do after you saw the defendant?
I moved my vehicle close to him, got out, and put him at gunpoint, suspecting he may have been involved in the shots being fired. Due to the fact that he was in the area.
I'm gonna ask staff if we
see.
can switch
Now,
that around.
Can you describe what he was wearing?
I can. He was wearing a Gucci style dress coat with a pink waistcoat with a white undershirt, black pants, and black shoes.
Gotcha. Now, do you have a previous relationship or any previous interactions with the defendant?
None. First hand, although I was investigating for another incident prior to this one in question.
At this point, would you have been able to point out the defendant in, say, like a lineup, or would you have recognized him on scene?
As one Boogie Scott, no.
So, you place the defendant in cuffs, correct?
Yes, I moved up to him at gunpoint, he complied and was placed in handcuffs.
Can I ask, why exactly did you place Mr. Scott in handcuffs?
I placed him in handcuffs at that point to make sure that he was going to be no longer a threat to myself, because I could not ascertain at the time if he was a shooter or a victim. I acknowledged that he did have an injury or was limping, but I did not know if he was the aggressor in the situation or the victim.
I see. Now, once you said you saw him limping, correct?
Yes, I did.
Now, did you at first notice any specific injuries the defendant may have had? Or what did you attribute that limp to when you saw it?
From previous instances of shots being fired and finding victims, I attributed it to a GSW, a gunshot wound.
Okay. So at that point, when the defendant is in cuffs, when he's limping, what did you classify him as? As a victim, as a shooter, or somehow involved?
I classified him at that point somehow involved.
So what steps did you take after you placed him in cuffs?
After I placed him in handcuffs, more officers arrived to support me. However, I then conducted a gunshot residue test on said individual, and then began frisking him to making sure that if I did uncuff him, he wasn't going to pose a threat to me or anyone else in the area.
Okay. Now, during the course of that frisk, what did you feel on this person?
I felt a long-barreled firearm, also I believed. A small hand-sized, what felt to be a handgun as well.
Okay. Oh, in your experience as a police officer, have you handled many Class 2 or firearms in general?
I have.
Okay. Do you generally know what they feel like when they're located on a person during a frisk?
Yes.
Okay. So, again, describe what happened during and after the frisk.
Once I felt the feeling of a weapon, I then went and investigated further on the weapon by pulling it out of said pockets. When I pulled it out of said pockets, I found it to be a Tommy gun or a Gusenberg sweeper, and also an S&S pistol.
Okay. Now, when you had the defendant detained, did at any point you ask whether he had a firearm or other weapon on him?
I did not.
Now, at the time and during the arrest, did the defendant have a firearms license?
He did not. He was a convicted felon.
Okay. Now, did you find anything else on the defendant?
I found what I believe to be a packet of thermite and 2 oxycodone, as well as a phone and radio, among other effects.
Okay. Now, what did you do with all that evidence that you found on this person?
I documented the evidence before taking it off his person. I then put it on my person, then took it to Polito police station, where it was then catalogued into our evidence locker.
Now, still on the scene, right? You have the defendant in cuffs. You frisked him, searched him. At that point, were there any other individuals either on scene or any officers saying over the radio there were individuals in their custody or on scene?
I believe officers on scene did bring one individual to where I had held Mr. Scott. The individual was incapacitated.
Okay. Now, was there anyone else that you saw personally on the scene that was either injured, shot, or in the general area at all?
Not to my recollection, no.
But just to clarify, Mr. Scott was the only individual that was actually in the area of the shots fired. When you detained him, still only person that was there. And when you ended up transporting, still the only person that was found.
Not exactly. He was the first person that we found because he was standing and emerged from a building to the bank where we were canvassing the area. While we were canvassing the area and while I was investigating Mr. Scott, I did hear over the radio and LSPD officers bring a second individual dressed in all in black with a mask on to my location, which was incapacitated.
Okay. Now, on the ground, did you, let me clarify here, did you actually scope the area immediately around the defendant out? Did you sort of have a look around?
At the time, I couldn't due to the fact that I was the only one there at the time. Once other officers had canvassed the area, I did go ahead and have a swift reconnaissance, but I didn't find anything.
Now, did you see any sharp debris or matter that could have caused an injury similar to a gunshot wound on the area?
In the area in question, possibly. There was broken glass from the vehicles that were left on scene. But to my knowledge, I don't see any debris that could have caused such a wound to Mr. Scott's leg.
Okay. Now, do you have training as a medical professional?
I do have a certification in medicine, sir.
Okay. Now, did you examine the wounds of Mr. Scott further, before or after he was detained?
Your Honor, if I may object,
Go ahead.
if he could restate that, because I couldn't hear what he said. What type of medical certification? I didn't hear that.
Could
Well,
you
Your Honor,
possibly restate it? Or, Mr. Hall?
Do you have any sort of certification or training in terms of being a medical professional or administering treatment to an individual?
Yes.
Okay. Can you clarify what that training is?
So, as part of my training as a San Andreas State Police Trooper and being a first responder who's first to the scene of many a crime, I am trained to be able to give life-saving triage as well as everyday first aid to an injured civilian.
Have you ever had to provide first aid, either during your training or in a real sort of situation, to a person that has been shot?
Yes.
All right. Would you be able to discern what is and what is not a gunshot wound?
Yes.
Now, I'd like to take it back to the scene with the defendant. Could you discern whether or not the defendant was shot?
He was shot in the leg.
Okay. And did you notice that when he was limping or when you fully had him detained?
I noticed that once he was fully detained.
Was this before the frisk?
Yes, it was, I believe.
Okay. Now, again, can you just run me exactly through what you seized off of the defendant? If you need, I can bring up specific exhibits if you can't recall from memory.
If you could, I can recite very quickly. He had one Gusenberg sweeper, one SNS pistol, one phone, one radio. Both the phone and radio were returned to Mr. Scott per recognizance, which he was let out on, pending this court trial. One packet of what I believe to be thermite, 2 oxycodone, and I would have to refer to the exhibits in question for further.
Did you serve any ammunition off of the defendant?
Yes, I did. 7.62 millimeter and 5.56 millimeter.
Did you take any pistol ammunition off of the defendant?
Yes, I did also. 9mm.
Now, would that ammunition suffice to load a Class 2 as well as a 1 firearm?
The Gusenberg sweeper, which I was told by Mr. Scott in questioning under Miranda, is loaded by 45 caliber bullets, so I believe so. The 7.62 millimeter and the 5.56 millimeter, however, do not go into either gun. They are for a rifle, such as an AK or a G36 carbine.
Okay. Now, can I ask, why did you seize the thermite off of this person?
From previous experience from dealing with certain bank robberies, it's been a common trait among criminals to use thermite to blast open security locks for doors. Being that it was a potentially contraband item and something that some normal person wouldn't have, I confiscated for further investigation. I questioned Mr. Scott on it later.
Okay, and what was his response?
He had no idea it was on his person.
How the fuck does someone not know they had thermite? What the
If you
fuck?
could. Of course, maybe questions in terms of the frisk that was performed. Now, can you confirm or deny whether the frisk that you performed on the defendant was in line with all case law and training that you have as an officer?
To my knowledge, yes.
Now, as a trained law enforcement officer, did the defendant, 1, being on scene of a shooting, 2, being injured and limping, suggesting that he was shot, and 3, being in trying to hide from officers on scene, give you enough cause to actually detain him for questioning and frisking?
Yes.
No further questions, Your Honor.
Okay. Mr. Vandeburg?
Yes, sir.
Do you want to approach?
Yes, I do. Hello there, Trooper Ward.
Yeah,
Hello, sir.
everything was RS.
Well, so I have some questions here for. My first question is in regards to this. Let's go back to when you
His
said you
Terry
saw
frisk was not
injuries
illegal,
to
by
his
the way.
leg. Let me take
Just
a
gonna
look
say
here.
that right now.
You said he was shot in the leg, but but the Exhibit A that prosecution presented that I saw on your body cam doesn't show any injury to his legs. Why'd you say that when it shows damage to his upper right arm and his lower
right.
left arm?
That's the exhibit he's talking about right here.
It's possible that someone could have been struck in the leg and then medicated it using things like IFAX, bandaging, and gauze. So it's possible I could have missed it or misinterpreted it as a GSW wound rather than anything else. However, the wound at the time I did believe was a GSW wound.
But you said that you have medical training in first aid and triage. Wouldn't you not know that you would see that his leg was treated?
Yes, and not necessarily. For example, an opened stitch has come open could be misinterpreted for a stab wound, or vice versa.
Wouldn't seeing bandaging on the leg be pretty obvious, even to someone not medically trained?
Not if Mr. Scott had his pants on, which he did, and could have concealed the bandaging, which I did not check at the time because I was trying to detain the individual and secure a threat to that of my officers and myself at that time.
All right. Now, going over to the detaining, or actually, let's go back a little bit. Okay. You said you found my client in the area where the shots were. If I remember correctly, why did you say that when, if you look at, bear with me one moment here, at My apologies, just make sure I'm saying this right. At 1 minute 9 seconds, there was a 911 call for a shooting at Polito Boulevard and Pyrite Avenue, which is an intersection, which is a T intersection. Why did you say that when he was found at Procopio Drive?
The 911 call is a general location search as to where the shots been fired. We did have other reports which narrowed down the search parameters, as we didn't search the far west side or the far east side. We concentrated on search on Polito Bay itself, between the bank and towards Julo's Ave. And if I may add also further.
Yeah.
People have two legs, they can move. So from the reported shots fired, the individual can move to another location.
The individuals have 2 legs and can move.
All right. But also, if you go look at your video, or your body cam, I saw you drove by 2 bodies laying in the street. Did you not want to bother, or why didn't you bother stopping to search those 2 that were laying in the street, potentially lifeless?
Okay, so I must have missed them in the first initial sweep through my canvassing. We did have other officers on scene as well, looking for them also. In addition to that, my being one of the first units on scene as well at that time was securing the scene, making sure there were no threats to their lives. I can understand that they were bleeding out, but I need to make sure that my life and anyone else who's still in the area and still standing is not in jeopardy, and I don't have more casualties.
Okay.
Perfect answer.
Let's see here.
That's a good answer.
You also stated that you were the only one on scene when you pulled up to my client at that back of that house. However, 4 minutes 50 seconds into your body cam, I clearly hear a female voice that later turns out to be I believe those 2 chevrons indicate she's a corporal, that walked up right beside you and told my client why he's being detained. Why would you say you're alone?
Because she arrived after me, and while I did not see her, she could have been behind me, say 5 or 10 feet, but my body cam could still pick it up. I did see her at the corner of my eye while I was holding the guy at gunpoint, some minutes later.
Would that not be relevant to why? Sorry, let me rephrase my question. Why didn't you clarify that for the courts instead of making it sound like you were alone for some length of time?
Because at the time I was in a lone patrol unit, canvassing the area for bodies and suspects at large who could pose a threat to myself and also the public at large in Polito Bay. So at that time I was alone. And when I did get to Mr. Scott, I was alone in the vehicle putting him at gunpoint. The female officer, Officer Moore at the time, did run over and give me support a minute or so after I'd made contact with the individual.
Right. Now then, let's see here, going back a little bit here on
That's
your
a
body
dumb
cam.
question from Edward.
You told the prosecution that, as far as you're aware, that my client was the only one in the area. However, if we go back to 3 minutes 40 seconds of the body cam, a man rear ends you and then proceeds to get out and charge your car. Why didn't you go after him?
I believe you're referencing the old occasion on Gratian Highway entering Polito, is that correct?
No, 3 minutes 40 seconds. You were driving down Polito Boulevard, and I believe that's called an Emperor. Rear ends you, and the driver proceeds to step out and charge towards your car before running off because you were backing into him.
I'm going to object on the basis of relevance at this point. Overall, what this officer may or may not have done should or should not have done necessarily, has really no basis in terms of determining whether the defendant is guilty or not guilty. Simply an officer, someone running into him and then him driving off has nothing to do with this case.
I agree.
Your Honor, may I rebut to that?
Yes.
However, the fact is that could have been the shooter. And for the fact is, if we go look at, let's see, if we look further at the video, if we look further along the video, it actually shows that there were 911 calls of, let's see here, a people driving off, going down the opposite way. Actually, hold on. Actually, let me read about that. Actually,
Yeah, he fucked himself on that one.
there was someone
Edwards.
going down Polito Boulevard, or is that Polito Boulevard? Yeah, let me look at that. That was there was a 911 call for a man with a class 3 in that same exact location. Again, referring to Polito Boulevard and Pirate Avenue. Then 911 call for a hit and run. Then for a call for a 911 call at 1 minute 35 seconds at Polito Boulevard. Again, doesn't specify which directions because it could have been east or west. But again, the fact is that the officer said that, as far as he was aware, that my client was the only one in the area. But that man who rear-ended him
Yeah,
counts
he's
as a
trying.
person in the area and proceeds to show aggression by charging the trooper's vehicle. That's why I'm asking about that gentleman, because that man, I don't know what his reason was, but he was charging a vehicle, he was charging a police officer. I can't assume what he would have done, but it didn't look like it was to say, I'm sorry, the way his body was moving. Showed aggression.
That's assumption, speculation, objection, speculation.
Give me 1 second to talk with Mr. Peterson. Trooper Ward, you do not have to answer that question. We're going to uphold that it's irrelevant for this case about that gentleman.
Okay.
Mr. Vandeburg, you continue.
Objection
All right.
sustained.
Trooper Ward, again, you told us that you are a patrol trooper with 3 months experience. Do you know what Terry versus Ohio is?
Yes, I do.
Okay. Again, as a patrol trooper with 3 months experience, you know the difference between reasonable suspicion and probable cause?
I do.
Okay. All right. Getting to that point.
This is gonna be good right here. I
So-
like this part.
From my understanding, with reasonable suspicion and probable cause, was seeing my client there reasonable suspicion at that scene?
Yes, it was.
Okay. Now then, with your experience, Trooper, isn't, and to my knowledge, and you can visually see, was my client visually armed?
He did not have a holster on, so no, he was not armed, to my knowledge. However, this is a concealed carry state, and people
It's a
can
yes.
fall- No.
It's a yes or no. Okay. All right. Now then, is it normal procedures for the state troopers to pull out full-on assault rifles and point it at an unarmed, injured man?
In terms of shots fired call, well, we have had, as you stated before, reports of a class 3 being used, or a rifle. It is then procedure to use match with force, and for that rifle, yes. But it is LEO's discretion.
So, aside from that situation there, that's unusual, but let me try to think of the question here on this. Let's get this going. You understand? My apologies, John. Let me rephrase the question because it was. I understand you detained my client for reasonable suspicion, but you also did a GSR test. What did that GSR test come back as?
He came back negative, as stated in my report.
All right. So, from my understanding of reasonable suspicion, being my client was cleared of the GSR, why did you then
I
proceed
want those hats
to
off in court.
frisk him without his consent? Being your reasonable suspicion was destroyed.
It was not destroyed, sir. Reasonable suspicion came from the fact that he was in the area on the shots fired call. He may have something to do with it, he may have seen the crime. He may have been witnessed it, he may have been a victim. I couldn't say that for certain at the time. However, I detained him on scene because I believed at that time, since he was in the area, and he was hiding behind a building to my knowledge, he may have been involved. So he was cuffed, and due procedure, I GSR tested him in case he had fired a weapon. To continue my investigation further, he came back negative. However, also that did not infer that he was a part of the crime. He could have simply taken the weapons from someone and simply ran. I did not know at the time, that's why I frisked him. The frisk was also to protect my officers and also myself, because if I were to uncuff him at any point in time, say for example so that he could eat and drink, and if he had pulled out said guns that were found in evidence, then that would pose a threat to my life and that of the other officers on scene later on. So yes, I still had reasonable suspicion.
It doesn't make any sense, but so aside the fact that you were pointing a gun at an injured man who was not visibly armed and came back GSR negative, let's see. Let's see. Why didn't you ask him about his injuries?
Because at the time I was, again, as I stated to the prosecution, my role at that time was securing the area, making sure there was no active threats to my life or that of any other. After I had secured that, I would then go ahead and treat him, if I could.
But he's not considered a threat as long as he's detained, right?
Correct.
Then, and because going back again to 4 minutes 50 seconds in your video, you had the you said Officer Moore there. Why didn't you just have her secure the area?
Due to a ongoing case that Officer Moore was involved with, she and another officer had to break away from the situation. I can't discuss that further, but at that time I was left with about 3 other units on scene.
Okay. All right. So let's see here. Why didn't you ask him why he was in the area?
Because at that time I could not determine whether or not he was going to be an aggressor or a victim, and at the time of finding the weapons, I believe at that time I had sufficient probable cause to arrest him on just based the weapons alone.
Well, going back before you searched frisk him, I still need that question answered as to why the fact you didn't ask him why he was in the area.
Your Honor, asked and answered.
No, that's after the forehand, Your Honor, the rebuttal on that. That's basically, the fact is that it's avoiding the question of saying why he didn't do it after. We're still at the point where he's being GSR tested and found negative.
Your Honor, if I may go into a bit of a description here. Overall, this question has been asked and answered before, right? And it's not necessarily very relevant to speculate what the officer should or should not have been doing. We're talking about the facts of the case, what did actually happen. The officer, it seems like he didn't actually ask him those questions, so we should move on.
The rebuttal on that, Your Honor, is the fact is it's important
It's been asked and
as to
answered.
establish his reasons, because my client could have said, well, I just fell down the cliff and was climbing back up. That's my reason, Your Honor.
I'm going to sustain the objection.
Okay.
There you go. It was asked and answered. Good
All
job,
right.
man. Fuck yeah, man.
Again.
All right, yeah, let's see here.
I like Mann as a judge, guys. He's doing good. He's doing really good.
Give me one moment, Your Honor. Bear with me a moment, Your Honor. I'm just trying to make sure I'm doing this. Got all my questions here.
Mr. Vandeburg, in the interest of time, I would request that you go and have your last questions prepared.
Yes, Your Honor.
We've been going on for a bit long at this point.
Yeah, yes, Your Honor.
He didn't like that. Vanderbilt didn't like that.
All right. So in regards to this here, Trooper,
Do we only have
being
one
you
witness?
said that my client was proven GSR negative, but you still insist that there's reasonable suspicion
There's only one
just
witness.
because he's in the area.
Trooper
and
Ward.
There's been other people in that area, not just him. You asked him if you could frisk him or pat him down. I couldn't hear your video because, frankly, your audio is very horrible on that video. Why would you ask him if you, or sorry, that's a dumb question. If he said no, why go ahead and do it? If you had no reasonable suspicion, or after he was already found GSR negative.
I've already said, sir, I did have RS, and while he was detained, and again, as I've said before, if I were to release him from those handcuffs and, treat him if I were, and he had weapons on him and he pulled them because people lie, there's something they can do, and he pulled out said weapons that we found in evidence, and I confiscated off his person that day, he could have used them to use on officers and the public at large. So again, he was detained, he was GSR tested, the GSR came back negative, I grant. However, again, as I've stated before, it did not mean he could have been a party to the crime or what was going on in the situation. An example could be he could have simply been a watcher calling out for positions of his cohorts. He could have been simply there and just taken firearms off a downed victim, or even taken the weapons of a suspect to remove suspicion from them, and then left the area, however, may have been caught up in the crossfire. I do not know that. I do know the fact, though, that he was there in the area, and he was injured. So at that point, I did still have RS to detain him and make sure he was no longer a threat to me. Granted, he was in handcuffs, but I wanted to make sure if I released him from handcuffs, he was no longer posed a threat to me or the officers. And lo and behold, he had a Tommy gun on him and an S&S pistol.
Okay. No further questions, Your Honor.
Your Honor, I do have a couple of questions on redirect if I'm...
Okay. Is that all you can redirect?
I'll try and make it quick in the interest of time.
Thank you.
Now, I'd like to ask, necessarily again, you stated prior you had training when it comes to establishing reasonable suspicion and probable cause. Is that right, Trooper Wood?
Yes, I do.
Now, would you be able to detain and frisk someone for shots fired calls if they are down, let's say they're in Polito, if they're down in the city? Would you still have reasonable suspicion if they were all the way down on the other side of the state?
Can you clarify your question? Do you mean if they were in a different part of the city or the
I'll
state?
rephrase. So if you get shots fired calls up in Polito, right, would you still have reasonable suspicion to detain and frisk a person that's on the other side of the state based on those shots fired calls?
No.
What about 10 blocks away from the scene? Mighty fine distance.
Indeed, normally I'd say no, but then the suspect may have gone into a vehicle and moved that distance or even ran that distance. I've seen it done before, so it is possible. However, I wouldn't necessarily say yes to that.
And if an individual is only 3 blocks away from the shots fired calls, would you have reasonable suspicion to detain and frisk them?
Yes, I do.
Now, would you be able to detain and frisk someone for shots fired calls if they are down, let's say they're in Polito, if they're down in the city? Would you still have reasonable suspicion if they were all the way down on the other side of the state?
Can you clarify your question? Do you mean if they were in a different part of the city or the
I'll
state?
rephrase. So if you get shots fired calls up in Polito, right, would you still have reasonable suspicion to detain and frisk a person that's on the other side of the state based on those shots fired calls?
No.
What about 10 blocks away from the scene? Mighty fine distance.
Indeed, normally I'd say no, but then the suspect may have gone into a vehicle and moved that distance or even ran that distance. I've seen it done before, so it is possible. However, I wouldn't necessarily say yes to that.
And if an individual is only 3 blocks away from the shots fired calls, would you have reasonable suspicion to detain and frisk them?
The general area of a shots fired call is relative, but at that time I believe so, yes.
Now, around how many blocks away was the defendant in this case?
I would say not even one. Maybe, I'd say 100 yards, that's it.
Okay. Now, just a few more questions here. And how familiar are you with gunshot residue tests?
Adeptly.
Well, that's very good to hear. Now, generally, how accurate can GSR tests be?
Very. It is very hard to get rid of gunshot residue from someone's hands, gloves, arms, sleeves, and handcuffs, etc.
Is it possible to wash gunshot residue off in, say, a body of water?
I would have to go ahead and say no, due to the fact that things like, from a gunshot, things like black powder and cordite are released, and they spray over a person's clothing, and that's dust. Dust is very hard to remove, and to remove that, you would have to go through rigorous cleaning.
Okay. And could that be done with water, or would there need to be a special solution to wash away gunshot residue?
It would have to be done with a special solution, probably bleach or something that could erode away particulates of dust or crystalline fragments.
Gotcha. Okay. Now, you go ahead and state, I don't know if you said this earlier, but how did you identify Mr. Scott on the scene or after you detained him?
I identified him via a fingerprint due to the fact he did not have an ID.
Alright, what did that fingerprint scan come back to?
It came back to one Boogie Scott.
Alright, Your Honor, no further question.
Okay. Mr. Vandeburg, do you want to reapproach?
No, Your Honor.
Okay. Mr. Ward, you are good to go back. You are free to leave if you want. Mr. Hall, does the prosecution have any other witnesses?
No, Your Honor.
Okay. Mr. Vandeburg, does the defense have any witnesses?
No, Your Honor.
Okay. We will move towards a closing statement. So if the prosecution wants to begin, they can approach and
Thank you, Your Honor. Now, ladies and gentlemen of the court, Your Honors, today, once again, I'll reestablish this. We have heard a fairly simple case today. We've heard Officer Warden, we've seen in his body camera footage, we've seen from the other evidence submitted that, of course, on August 24th, Mr. Scott, the defendant, was found on the scene of shots fired. Now, Officer Warden, through his knowledge and training as a law enforcement officer, knew that he had reasonable suspicion to detain Mr. Scott. He knew that he had reasonable suspicion to actually frisk Mr. Scott. And when Trooper Warden, frisked Mr. Scott, found a multitude of weapons. That, of course, allowed him to fully search the defendant and found more items, such as illegal contraband and Oxycontin, which, of course, is a controlled dangerous substance. Now, the main question at hand in this case seems to be whether or not it was reasonable for Officer Warden to actually search the defendant and frisk him at the time. Now, we have learned that it was reasonable. It is reasonable for an officer when they encounter an individual, whether that be a victim or the actual perpetrator of a crime, to detain them. If one is a scene that is dangerous, two, if it seems or appears that they may be involved through the officer's training and through the evidence on scene that they may be involved. Now, we have learned that Trooper Warden at the time of the scene, first off, had the defendant limping, which, of course, he immediately recognized to possibly be attributed to a gunshot wound. Two, we have the defendant being on scene of shots fired. And three, we have the fact that no other witnesses, no other individuals were identified by either Trooper Warden or other officers to be on scene of the crime during the detainment. Now, those three facts alone attribute to reasonable suspicion and do allow for Trooper Warden to actually detain. And no matter what any sort of gunshot residue tests discern, to actually frisk the defendant to ensure that he didn't have any weapon, but didn't just wash his hands off in the ocean that he was just by, or that he didn't in fact shoot at the time, but was still armed and dangerous in detainment. So all of this combined leads us to believe that the frisk and subsequent search of the defendant was lawful, and everything found and submitted into evidence shows his guilt beyond a reasonable doubt of all charges brought before this court. Thank you, Your Honor.
Mr. Vandeburg, you may approach.
Yes, Your Honor. Your Honors and people of the court, despite what may have happened here and what the explanation of the prosecution was, and based on what Trooper Ward has stated, the fact of the matter is that officers are not lawyers. Neither are they medics. I understand if Trooper Ward may have had some medical first aid, which, you know, is pretty basic stuff, and some understanding how to treat people who are multiple people being down. The fact of the matter is, though, the Trooper Ward admitted in court that he drove by 2 down people, but used the excuse that it was for looking for this injured person, rather than saying I got 2 people downed in the street who could have been run over by other cars, and we can't prove if they were later on or not. The other situation was, of which, you know, the sustained question about the gentleman who rear-ended him, which I guess was proven to be irrelevant. The fact of the matter is that how this was all approached is very questionable. The fact of the matter is that the female officer, who clearly could be heard on the radio, saying that there's a man they spotted, that's where Trooper Ward turns around, goes down, my apologies, I don't mean to butcher the name of the street. Let me get that pronounced correctly. So I found him at the house on Procopio Drive. I understand it's less than a block away from the scene. However, my client emerged from the back of that house in a way that officers didn't know how he came back there. He could have been fallen from the cliffs, and he could have been injured. Although the officer wants to say that it was gunshot wounds. However, there's wounds to his arms, which could easily be done by sharpened rocks, which was clearly pointed out in Exhibits 2, 3, 4, and 5, noting how steep the area is. Now then, I understand, with them saying, they had reasonable suspicion. The reasonable suspicion is this. He was in the area, and they detained him, of course, for their safety, as what Corporal, or we'll just refer to generally Officer Moore, had said, we're detaining you, sir, for your safety, as my client was complaining as to why. The problem is, too, is that I understand it was an active shootout area, and they wanted to meet force with force. However, it seemed a bit excessive to point a full-on 5.56 assault rifle at my client when he wasn't even visibly armed at the time, to their knowledge. A taser would have been proper enough, and they were close enough that a taser would have reached him. The fact is that I feel that excessive force was used with that rifle pointing at my client. And let's see here, going on, when they did that, they go up to approach my client and they want to GSR test him. Well, they GSR tested him. He came back negative. To me, that destroys reasonable suspicion. And at this point, the officer should have just asked him, what was he doing there? Why? What was wrong? Why did he get hurt? Instead, they proceed to profile my customer as my client, my apologies, as a criminal, and proceed to unlawfully violate Terry versus Ohio and frisk him, and then find the evidence which falls under the fruit of the poisonous tree doctrine, and then proceed to go on from there and violate his rights further by searching him. Your Honors, and people of the court, reasonable suspicion was destroyed when the GSR test was found negative. They had no further cause to go forward with a search other than ask him some questions, which he had all his rights to say no to, and they shouldn't have carried on any further and just moved on. Whether he was there or not, there were plenty of other people there. Like I said, 2 dead people in the street, man that rear ends another. There were other vehicles on that road driving into the city. And who's to say that the guy, in the direction as it was called out that a man with a Class 3 was spotted on Toledo Boulevard Bay in San Andreas, though it doesn't say east or west, that could have been the person driving away or getting away. But they proceeded to just go after my client. My client wasn't even the shooter. My client's not the shooter. I understand they found some illegal firearms, which were fruit of the poisonous tree, but it doesn't prove that he was the shooter. Your Honors, I'd find it that this is very unusual and very disconcerting that the officers took the actions they did and proceeded to treat my client so harshly and coldly, and not consider the fact is they left him there for minutes on end, and depending on how he's bleeding, they could have hit any of his arteries on his arm. He could have been bleeding. He could have been bleeding to death at that scene. I mean, shouldn't the officer show some heart, or at least put something to stop the bleeding? Because at least not until the end, when the EMS chopper arrived, was he being treated for his wounds. They could have at least cauterized his wounds, or at least a tourniquet would have helped. But no, they proceeded to just frisk him. So, Your Honors, I find that this was a violation of Terry versus Ohio, and that my client should not be found guilty of such actions, despite the fact the items on him were illegal. That is all, Your Honor.
Thank you, Mr. Vandeburg. Okay, this court will be in recess for 10 minutes whilst judges deliberate. All rise. District Court Andreas now back in session. Okay.
Yeah.
So
They can detain ID.
In the case of the State of San Andreas versus Boogie Scott 21-16279, this court finds Mr. Boogie Scott guilty of all charges, which those being PC 2302, possession of a Class 2 illegal firearm, possession of a firearm without a weapons license, possession of an unregistered firearm, failure to inform of a concealed weapon, possession of a firearm by a convicted violent felon, illegal possession of a Schedule II controlled substance, and possession of illegal contraband. Also, Boogie Scott will be getting will be also having the charge of failure to appear applied on, as Mr. Scott had not informed the court that he would not be able to appear, and he has he did not show up, so the court will be applying that charge on there. The docket will be updated with the full list of reasonings and charges in 48 hours. And then a time period of 72 hours will be given for an appeal window for both sides to be able to appeal. This court is adjourned.